Hi, welcome to Property Decoded. I'm Jayashree Kurup. I have with me Prabhakar Sinha. He's the real estate editor of the Times of India. And I have Sudip Mullick, who is the partner, Khaitan and Company. And today we're talking about the Model Tenancy Law, a very well-drafted law, right, Sudip? How do you think it is going to impact the tenancy markets in India?
You see, let me tell you, this is a great step, and provided, of course, the state governments do adopt it. But I find a little bit of difficulty in understanding the definition of landlord and the tenant. I believe the intention is to have only tenancy agreement. But if you see the definition of landlord, it speaks about a landlord or landowner or a lessor or in whatever named called. This gives the flavor as if this is not related only to tenancy agreement. It may also bring within its ambit a lease or a licenses that are usually done, particularly in case of commercial, certain cases residential also. But if you see the definition of tenants, there it says that it is where parties, landlord and tenant, is entering into an agreement of tenancy. So it looks as if it does not deal with lease or licenses. Now, this ambiguity should go. This is number one.
Yeah.
This act also applies, as you know, to residential, commercial, industrial, does not apply to industrial and educational institutions. Now, if you are to bring within this act the commercial premises, then you need to do certain things in this act itself. This is a very good, well-balanced act, but there has to be freedom of the parties, particularly with regard to security deposit. There is a cap of 2 months and 6 months for residential and commercial units. Now, if that 6 months may not be good enough, plus when you enter into commercial documents, there is a requirement that, say, suppose the agreement is for as long as 10 years, and there is a requirement to utilize the security deposit for various things: non-payment of rent, non-payment of amenities, non-payment of essential and utilities, and there is a requirement to top it up if the landlord draws from that. There is also a requirement to top up when there is an increase in the rental. Say, suppose in a 10-year period, after every 3 years, the rent increases by 10% or 15%, then the security deposit correspondingly increases. I think it is best left to the landlord and tenant to agree instead of trying to cap it. There is no requirement for the legislature. It will be a market force that will determine. That is how you will also find, both in case of residential and commercial, premises, people, investors, particularly institutional investors, who will then find it very interesting to be part of it. Why do I say that people will find it very interesting to be part of it? Primarily because the mechanism, the dispute resolution mechanism, is in a time-bound manner, as opposed to going to regular courts or arbitrations. You see, leases can in some cases go to arbitrations, but this mechanism will be a quick fix and an easy solution. So this way, there are people who are renting out commercial, who are interested in investing in commercial premises, they may shift from the existing lease and license structure to this structure. So there is a possibility in doing so. This is the first, these are the first few thoughts I have when I saw the act itself.
So, do you think that when the states enact the legislature on their own, that is when they will make these fixes? They can make these fixes?
The question is whether states will adopt, because you see, the states will adopt, not adopt. I do not know whether they will do so, and whether it suits them to do so, because already there are existing rent control acts. Now, existing rent control act also brings about protection of tenants in certain cases, or payment of standard rate, or increase, or a fixed rate of increase, or deals with all these very typical issues of various states, which is a culmination of various events, happenings of the past, so those, whether the states will be able to, come out of those and be able to enact this.
Yeah.
This is a very progressive piece of legislation. What will also happen is, because of uniformity, the investor community may be interested in investing, because you see, when please understand, when an institutional investor comes, the moment they have the whole process of institutional investment is standardization. Now they don't, if you give them a standardized thing, then it will be very attractive. Now, if you see in the West, or in any developed society, things are done in a very standardized box after box after box manner. There is very little application of mind. That helps in productivity, and that removes any conflict. So maybe that is the intention in promoting this model act. Now, whether the states are in a position politically or psychologically, or for local pressures to do it or not, it's very difficult for me to say.
A couple of states have already declared their intent to look at this legislation, right?
Look at this legislation and enacting it are two different things.
Yes, absolutely. Prabhakar, you have this thing of which states have shown interest?
UP has already done it.
And
UP cabinet has already approved it. Now only rules has to be framed in UP. And in fact, in UP, this act has been enacted retrospectively. Though this act, Model Act, is only for prospectively. Whereas Haryana government has also circulated similar Model Act, in fact, 2 years back itself, but they have not taken as yet the final decision. But I am told that now they are also moving very fast. Particularly with this act, the entire real estate dynamics is going to change. Now mind it, Jayashree, that today you want to buy a house, or you are forced to buy a house for the safety reason, because you might not get a good home at the rainy season, because your landlord might think of it, boss, no, I should not rent it out. I had some problem in my family, and in future I don't want to get myself involved into any litigation, so I don't want to give my house on rent. And so they might request you, ma'am, please vacate the house. Now with this legislation, what is going to happen, that many landlords will not feel threatened in giving out their premises on rent. So that means availability will increase. At the same time, for me, a person who is going to take a house on rent, for me, it is quite assuring one that, boss, if I want to take a house on rent, it is available in the market. So that will make the entire marketplace very, very healthy. And so the predictive, not only that, the market nature will become very predictive. And so the investors will come in. So now a new dynamics of demand and supply will emerge in the market.
That's right. But I think the point that Sudip made, we should talk about it a little more. There's a whole legacy of laws, right? The Rent Control Acts, because of various events in the past. The act very clearly says it's prospective in nature, right? So Sudip, what happens to all the litigations that are carried forward? They are in various civil courts, and they have been in the civil courts for a while. So what happens if like in UP, this is enacted? What will happen then?
No, Section 747 of the Act very clearly says that, all the previous acts will be repealed.
Yes.
Now, it also says that if there is a litigation of the past, then the litigation will continue as if this act has not come into force under the old act. There is a saving clause under Section 47.
In which case, there are these old properties which the low rents are being paid, things like that. That will continue.
Jayashree, let me put it this way. This is a fantastic act for, if it is done, for progressive cities and where there are a lot of migrant workers, particularly younger people, who is fresh out of college, working in Bangalore, Calcutta, Bombay, Mumbai, and Delhi. If there is this migrant younger population, it is easy, and it will also be easy for for landlords or investors, people who want to invest in a property, they will not feel threatened. That previously people would be scared. Once I give a property, my property will go away, the tenant will not move. That is what Mr. Sinha is trying to allude to, and that is exactly what may happen. And that is all also institutional investors may come in. They may build large properties and they may try to rent it out and on the tenancy model. Now people are doing so. People have moved away from the tenancy model to lease model and license model, primarily because of the protection regime, protected tenant regime, primarily.
Yeah.
Now that once that goes away and once this is adopted, then it's a different thing. Now, what do you do about the past? About the legacy tenancy or protected tenant? Now, maybe time has come to look into. Maybe time has come to look into and whether the protection should continue.
No, sir, but like state like UP, which has done it in the retrospective effects. Certainly, in a state like Delhi, particularly, where a lot of property had been rented out is in 30s and 40s. And like in Connaught Place, there are shops which is rented out at 40 rupees to 120 rupees per month, and it is going on even today. Now, that kind of a situation might, if you say that, no, you start getting it vacated from tomorrow, then there will be a huge problem. But in some other pockets where this kind of problem is not there, and that is why it seems that UP government might have thought of it to do it retrospectively so that cleans the entire slate. Whereas, of course, like Bombay, Delhi, and some of the older city, this might not be a problem. So there the government has to rethink it again and again how to go about it. And finally, they'll have to go through it, because if they want the investment from outside to come in and the development to happen, then certainly they'll have to make the law more transparent and equitable, because the old act was not equitable. It is more tilted towards tenants, and it was leaving the landlords completely open to all sort of vagaries. So at least this law is protecting both sides and also leaving both sides open to the risk. So to that extent, I'm saying that not only this, those states who will think that this can be implemented even retrospectively should go ahead and do it. And it depends on the state government, because this Model Act doesn't force them not to do it in a different fashion. I believe this state government can decide on their own what to do and what not to do. Isn't it, sir?
Sudip, you want to respond to that?
Of course, any state legislature can do and not do and put in with appropriate amendments. And this is a model. This is a guiding act.
Exactly.
But the point that you made, and I'm going to reiterate that to make sure that I've understood it correctly. If it is if there is a ongoing litigation, the act says that you can continue with the previous regime, and those litigations will continue in the civil court.
As if this act has not been done. As if this act has not come into force.
Which means that the future is this act is the future, but the past can continue to be whatever it was.
If there is a litigation.
If there, and there seem to be litigations, no. The entire rental regime, there is so many litigations. Sudip, any estimate of how many, what percentage of the civil courts must be?
Very difficult for me to say. Actually, I have not done this. If I had known, then I would have done it.
No. So another thing that has been spelled out in the Act is the role of the management professionals, right? The property management professionals.
Absolutely.
And this is something that our Indian markets have not had. We have not spelled out their role.
Not really. You see, I will tell you already the property consultant, when we saw this property managers in terms of maintenance of property, when the maintenance business came in, we saw all the property consultants get into that business. Maybe the property consultants themselves will become property managers, or there may be a new set of people, but it will definitely professionalize the whole thing. And it will also bring about employment in terms of, there will be another set of people. I would say it will also generate employment, because there will be some people, if there is an institutional investor or even an individual investor, In that case, the property consultants may take upon the role of not only discussing the rentals, giving advice, but also in case in the event of any dispute between the parties, sorting out the disputes,
Which means that they could very well liaise with the courts and so on behalf of the landlords and tenants, right? Which is what as happens internationally.
Right.
So is it redefining the role of what we today, what the brokers do?
To a large extent, yes. You see, what happened is the role of, first of all, let me put it a bit crudely. First of all, when we were young, very young, anybody with an umbrella and anybody who has retired would be property brokers. They would just go out from as if that I am going to deal with this property. Then came the very sophisticated brokers. What RERA did was to institutionalize and make the brokers accountable for the first time, in terms of what they promise. They ought not to be doing certain things. They ought not to participate in misrepresentation. This brought about a sea change, and in terms of a sea change in the broker community as such.
Has it made any difference so far? I think the changes in RERA have been more at the developer end and at the consumer end.
No, but also I will tell you that misrepresentation or has gone to a large extent. Siding with the promoter or saying that hey, this will happen, that will happen. That story is gone completely. That and what also have happened is they have also tied up with larger brokers, the individual brokers, in order to also developers have become conscious that they don't want to get into a spot because of misrepresentation by a broker. So it organized the sector considerably. What I'm trying to say is this will also open up a revenue stream for the sophisticated brokers and property consultants. And this will be a new stream of business for them, and it will generate employment. That is the way I would look at it. And particularly the landlord will also be hassle free. So they will also, like, as if you have made a fixed income in fixed deposit in a bank, and you have appointed at a service charge, everything is done for you.
And do you think it has been defined enough, or you think there are some loopholes?
No, but these are things which will play out as the market grows. It will not be done overnight. I would say, for example, say suppose a widow, let us say a very old person, why a widow, a very old person, be it a man or a woman, and he wants to make a property investment, but he does not have the wherewithal to run every day. He will appoint a property consultant to do all the acts for him, as well as in the event of litigation, represent him in court and go and take. But he is looking at his earnings rather than, and earning in a mutual fund is at your own risk, or every earning is at your own risk. So every investment is at your own risk. So this may be another mechanism. This is another way to look at it.
The definition of this property manager, this role, how significant is it vis-a-vis what happened earlier? Even earlier, there were people who represented.
Earlier, there were people, but earlier, people would be hesitant. Now, if it has got the sanction of law, people will not be that hesitant, or people will look at it in a very different manner. Once you have the sanction of law, then the role and responsibility becomes very, very different, and acceptability to the landlord and tenant also becomes very different.
Will they? But here there is no identification, right? The rental agreement has an identification. The property has an identification, but the property manager, there is no.
It's a very good point, Jayashree. I have not thought about it, but it's a very, very good. There may be a requirement of register. It can be there. The law can provide for requirement of registration.
But the point I was making is that in RERA, property brokers have to be
registered. Yes.
Can there be a harmony?
Yes, of course.
Because the more
that will also credence or credibility to the property consultant.
That's right. Let's move to the codes, the structure of the codes. Would you like to explain to the consumers how this is going to function? Because there is a rent authority, there is a rent court, there is a...
The rent authority is the person who will do all procedural work, all registration and procedural, excepting in one, I may have missed a point, but please forgive me for that. Excepting in one case of dispute where the existing tenant has asked the landlord that you please carry out some modification, structural thing, and the landlord has carried out pursuant to an agreement. Yeah. And the landlord is saying, please increase my rent. Now, please increase my rent, there is a dispute. Then it will go to the authority. And the authority will determine, but in all other cases, all representations, authority will determine. Thereafter, it will go to the rent court and finally to the
appellate.
Is there any time, sir, for under which the rent authority has to decide in the matter, or should
yes, there are timelines. There are timelines in each of the cases.
The rent authority case also.
Therefore, what I am trying to say is these timelines are fixed. So these are the three authorities primarily, and there are timelines fixed, and that is why in the starting I said that the advantage of moving from a legal license to this regime is very big because timelines are fixed and the authority is fixed. So the dispute resolution mechanism will be over in not more than 12 months if there is at all a dispute. But it is 60 days, 21 days, things are disputes and things will have to be, an application will have to be disputed in 21 days. Sometimes it is 60 days. The time period is fixed. So therefore it will obviously hasten the process and people will get speedy remedy, and therefore this becomes very attractive.
Yeah. Jayashree, one thing here also, I believe that rent regulator and the first level, the rent court head could be the same person also. I'm not clear of this because I read this act again and again. The rent authority, the rent regulator and the rent court judge could be the different person, could be the same person because both have the similar qualification. Additional deputy collector, ADC, can be the both. So like in the RERA, where the regulator is also the judge also, the quasi-judicial power they have, and he also sit on the bench and the court also, and he is the chief regulator also. So in this case also, I believe that the rent regulator and the rent court judge will be the same person. And that is why I wanted to understand that suppose I have a dispute, or suppose my tenant is not vacating my house. Should I first file complaint, or should simultaneously I should file a case in the court also? Because if I file the case in the court, then it must be get decided in 60 days. Whereas I don't have read in the entire law that when the authority should also decide the matter within a certain fixed time period. That's I didn't find.
30 days. The authority is given 30 days.
Okay.
Right, Sudip?
30 days is for execution of the order of the court. So what I am saying, the rent authority's order will be referred in an appeal, can be referred in an appeal before the rent court. So these are two different authorities.
Yeah.
There are certain powers that are vested. Whatever powers the rent court has, the rent authority will also.
Sir, in RERA also, sir, the regulator, suppose I have some grievances from the developer.
There is no regulator here. The rent authority is not a regulator. He will not regulate the rent. He will not regulate anything. He will only determine, or he will do the procedure. The rent will be an agreement between the parties.
Okay.
And it is said very clearly that it is left to the landlord and the tenant to fix the rent. There is no regulation of that.
No, that means, Jayashree, the moment a dispute start, one should move to the court.
No, to the authority, right? You first approach the authority to get it sorted out. So here I would like
certain powers that the authority has and certain powers that the court has.
Yeah.
Now the authority has certain powers, as I said, mostly it is procedural.
Yeah.
Excepting in one case where I have found out that the authority has power to determine, that is when the landlord has carried out certain additions, structural changes as per requirement of the tenant, and that there is a dispute as to what is the additional rent that would be paid, it will go to the authority. But in most of the other cases, you will have to go to the court.
So which means that if there's a dispute, you first go to the rent court. You don't
Yeah,
need
because authority has other duties and formalities. For example, registering the document and things like that.
So if suppose my tenant is not vacating, he's overstaying, what should I do? Should I move to the court or should I go to the authority?
to my mind, you will go to the court. Just give me 1 second.
Oh. But if you register a document, it has to be registered with the authority.
Authority.
Right?
Yes.
Yeah, that's with the authority.
So operationally, procedurally, you go to the authority for any dispute resolution. You
Correct.
go to the court.
Yes.
Oh.
It is. You see, section 21(2).
Yeah.
It says the rent court may, on application by the landlord, make an order for eviction. So for eviction, it is the rent court you have to go.
Okay.
So in a nutshell, what do you think this will do to the rental market? If I'm a landlord, there is 1.1 crore houses in the census 2011 that was
if you allow the security deposit structure to be as per market requirement and as the market decides, I think this is a very attractive act.
Okay.
And again, the only issue that will come in certain states where the protection regime is there for certain class of tenants, that if it is decided, but again, one will have to look at, you see, protection tenant regime comes from 2 factors. One is because of migration that happened during partition and the people there was inadequacy of housing. The other is, for whatever reason, some people in those days paid pagri or salami, which was equivalent to the price of the property, but they carried on as on a rental basis. Be whatever it is, if you want to clean the system, and if that is what it is, and if you want to bring those old properties, also the cities need to redevelop. If the cities need to redevelop and the old buildings has to go, because there is no initiative or for the landlords, either there is a mechanism that the existing tenant will buy out from the landlord at the present value or at a reduced value or whatever it is, to give shape to development and cleaning up of the city, accepting if it is a heritage structure, and to redesign the city, then one will have to really have a close look into that. And once that is sorted out, I think this is a fantastic act.
And
yeah, that's what I want to say. Yeah.
Yeah, go on, Prabhakar.
That is why, like city like in Delhi, this act has been suggested that it should be prospective in nature, not retrospective. I believe that this is mainly keeping in mind of the past, the Delhi past and the Bombay. Like in Bombay also, there are many chawls where the people are staying for last 50 years and 60 years with 10 rupees and 20 rupees rent, and they are not vacating it.
All heritage cities, no, Lucknow, Bhopal, Indore, you may have the same problem.
They have the same, but UP government
control acts were in every state.
Yeah, so that is why I believe that state government has left, the central government has left it on a state government to decide on those matters, and UP government has thought to build the cat, saying it, boss, we will take it to the retrospective effect, and even those who have taken it rents 50 years back, now they should also come for the scrutiny, that whether if the tenant, if the landowner want it should be vacated, then it should be vacated because it is their property.
Sudip, how does this law help the Affordable Rental Housing Act? You know, there is a proposal for affordable rental housing, right? Which is something that we haven't had earlier.
Whichever you see, once this law comes in, and if it is a free affordable housing, why will anybody be interested in giving it out rent if it is free flowing, if it is not, the rent is not determined by the market conditions?
Yeah.
Of course, because it will have the same effect as in all other cases.
Except that the tenure, the security of the tenure is not there. For instance,
No, Jayashree, what I feel here is that except in Bangalore, where the security is not, particularly in the residential, I'm not talking about the commercial property.
Yeah.
In residential segment, in Bangalore, the security is for normally 1 year. Otherwise, in other market, it is 2 months or 3 months. Okay. Now they have kept it 2 months mainly, and I believe that, I mean, I am for it, Mainly because suppose a student is coming here to take a flat on rent. Now suppose landowner wants that, boss, you pay 1 year security, then certainly that student will not be in the position to pay that. So there is some provision to protect the tenant also. And mind it, another very good provision for the tenant, there they say that if landowner wants to visit his own property given out to tenant, he must give notice 24 hours.
Yes,
So,
and sunrise to sundown, right?
yeah, sundown. So these are very good provision for the tenant also.
Sure.
And this act is trying to protect the interest of the tenant to that extent.
No,
There's nothing wrong in that.
About that. I was talking about the affordable rental housing. In affordable rental housing, the migrant labor, that is largely to cater to the migrant labor. And when you have migrant labor, the security of tenure is not a year. It cannot be a register. It's not a registered document right now. So how does that fit into this regime is what I was asking.
So give it for 6 months or 1 year. And now 2 months is the maximum. Okay. Now, if you feel that these tenants are good enough, you give them for 1 month security or 2 months.
Sudip, migrant labor is not does not follow these fixed norms, right?
I understand that, but Jayashree, whosoever is investing, he will also look at it for his return. Whosoever is investing will also know who the occupants are.
Right.
He will also know what the occupants can afford and what he will offer that to the occupant. If the migrant labor is entitled, or if they want to give a security deposit of 15 days and that is the market practice, then that is what will hold the fort, you know. So there is nothing.
It means that for the affordable rental housing segment, you may need to define it better, right? You may have to define it again.
Really, I do not know whether you need to define it better. Again, I would say that let it be with the investor and the occupants.
Yeah, it's a market
dynamics. The question
dynamics.
is, a person who is making the investment, he is looking at return, and the occupant will not stay there. The question is, if it is not affordable to him, he will not stay there. It's as simple as that.
It's market dynamics.
So net, it's a good law.
Of course,
the states need to. It's prospective. UP has made it retrospective. How that will play out, we'll have to wait and watch. But overall, you feel that it is a well-drafted law. Now we have to wait and see whether the states adopt it, right?
Absolutely. Yes.
Now the rules has to be framed. Now let's see that what kind of rules they are coming out with.
Yes.
Now all those things will finally decide the fate of this act and how well they are going to be implemented.
Even the Maharashtra Urban Housing Minister has said that ministry that minister has said that they are also considering the law. They're checking it out. After all, it is a defining moment. How it works, we have to wait and watch.
There will be huge pressure from the various stakeholders to implement this.
Absolutely. Thank you so much for joining me. Thank you,
Jayashree. Thank you, Mr. Sinha.
Bye.
Bye.
Thank you, sir. Bye.